So now in the chapter 4, today we'll read about arrest with and without a warrant, exercise of power and execution rules, proclamation and attachments. And under this, we'll read section 35 to 46 and section 62, section 72 to 75, 79 to 83, and section 84 to 93, which is coming under chapter 5 and chapter 6. So a couple of the sections are from chapter 5, which is arrest of persons, and couple of sections are from process to compel appearance, in which we have part B, which is warrant of arrest, and part C, which is proclamation and attachment, which is considered part of this chapter in the syllabus. Now, let's start with section 35. So whatever is written at the start in the chapter, arrest with and without warrant, is blah, 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 whatever literature, that is all covered in these sections. So let's start with section 35. So section 35 to 46 and section 62, which we are going to read, is part of chapter 5, arrest of persons. The chapter name is arrest of person, which is chapter 5. So when a police may arrest without a warrant, which is the title of section 35. It says when a police can arrest without a warrant, where they don't need a warrant to arrest. So any police officer may, without an order from magistrate and without a warrant. So of course, a warrant is given by a magistrate. So an officer may, without an order from a magistrate and without a warrant, arrest any person, number A, who commits in the presence of the police officer a cognizable offense. In presence of the police officer, if the person commits a cognizable offense, or against whom a reasonable complaint has been made or credible information has been received, or a reasonable suspicion exists that he has committed a cognizable offense, punishable with imprisonment for a term which may be less than 7 years or which may extend to 7 years, whether with or without fine, if the following conditions are satisfied. Namely, the police officer has reason to believe, on the basis of such complaint, information, or suspicion, that such person has committed the said offense. Now, see, very clearly it is written, the police officer has reasons to believe. So, reasons to believe on the basis of any such complaint, any such information received. So, complaints are very formal. Information might be informal. So, if he or the police officer is receiving some informal information also, which is an information, then also they can act, and they can also act on suspicion, but it has to be reasonable suspicion. Point 2 says the police officer is satisfied that such arrest is necessary, and then it says to prevent such person from committing any further offense, for proper investigation of the offense, and to prevent such person from causing evidence of the offense to disappear or tampering with such evidence in any manner, to prevent such person from making any inducement, threat, or promise to any person acquainted with the fact of the case, so as to dissuade him from disclosing such fact to the court or to the police officer. And point E says, as unless such person is arrested, his presence in the court whenever required cannot be ensured, and the police officer shall record while making such arrest his reason in writing, provided that a police officer shall, in all cases where the arrest of a person is not required under the provision of this subsection, record the reason in writing for not making the arrest, or against whom credible information has been received that he has committed a cognizable offense, punishable with imprisonment for a term which may extend to more than 7 years, whether or with or without fine or with death sentence, and the police officer has reasons to believe on the basis of that information that such person has committed the said offense, or who has been proclaimed or as an offender. So he was proclaimed as an offender either under this Sanghita or by any other order of the state government. So proclamation literally means to make a formal announcement. So if the person is announced that he is an offender, so he's a known offender, or in whose possession anything is found which may reasonably be suspected to be stolen property, and who may reasonably be suspected of having committed an offense with reference to such thing. or who obstruct a police officer while in the execution of his duty, or who has escaped or attempts to escape from lawful custody, or who is reasonably suspected of being a deserter from any of the armed forces of the Union, or who has been concerned in or against whom a reasonable complaint has been made, or credible information has been received, or a reasonable suspicion exists of his having been concerned in any act committed at any place out of India, which, if committed in India, would have been punishable as an offense, and for which he is under any law relating to extradition or otherwise liable to be apprehended or detained in custody in India, or who being a released convict commits a breach of any rule made under subsection 5 of section 394, or whose arrest may require arrest and requisition, whether written oral has been received from other police officer, other police officer has asked for his arrest, and provided that the requisition specifies the person to be arrested and the offense or the cause for which the person has to be arrested, and it appears thereupon that the person might lawfully be arrested without a warrant by the officer who issued the requisition. And subject to the provision of section 39, no person concerned in a non-cognizable offense or against whom a complaint has been made or credible information has been received or reasonable suspicion exists of having so concerned shall be arrested except under a warrant of order of a magistrate. And the police officer shall, in all case where the arrest of a person is not required under subsection 1, issue a notice directing the person against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offense, and to appear before him or at such other places as may be specified in the notice. Subsection 4 says where such a notice is issued to any person, it shall be the duty of the person to comply with the terms of the notice. Number 5 says, subsection 5, that where such person complies and continue to comply with the notice, he shall not be arrested in respect of the offense referred to in the notice unless for reasons to be recorded by the police officer is of the opinion that he ought to be arrested. And subsection 6 says, where such person at any time fails to comply with the terms of the notices or is unwilling to identify himself, the police officer may, subject to such order as may have been passed by a competent court in his behalf, arrest him for the offense mentioned in the notice. So he needs a permission from the court. And the last subsection 7 says, no arrest shall be made without prior permission of an officer not below the rank of DSP in case of an offense which is punishable for imprisonment of less than 3 years, and such person is infirm or is above 60 years old. So in case of a person who is above 60 years old, is infirm, or somebody who has committed a crime which is of punishment of less than 3 years, so no arrest can be made without the permission of a DSP or an ACP in the terms of the commissionerate-based police stations. So what is this section talks about? This section talks about authority to arrest without warrant. So the overall this section talks about, as per section uh, that this particular section 35 talks about the authority to arrest without warrant. So overall, this will have in which conditions the police officer can arrest without warrant and which conditions they cannot, and if there is any specific uh, exceptions around that. Now, subsection 1 talks about the presence during offense. So an officer must be arrest somebody. There is a very first condition is when a person commits a cognizable offense. Cognizable offense word is very, very important. And in their presence, if this happens, the provision ensures an immediate action by the police officer. So that is why the police is there. Or reasonable complaint and suspicion. So the police officer receives a reasonable complaint or even an information or have a strong suspicion. So in all those cases also, the police officer can arrest the person to prevent, what is the purpose? To prevent any further happening of a cognizable offense. For example, a police officer who witnessing a theft or a chain snatching or some crime like that can directly arrest the thief or on the spot. There is no bar on that. Or say, for example, if a reliable information comes and that a suspect is selling drug in such and such street corner, the officer now can, depending upon the information, or if somebody comes and gives a written complaint on the complaint, or if the police officer is passing by and by the way the person is operating and added with some information, the police officer might have a suspicion that this person is selling drugs, and the police officer can immediately go and arrest that person to proceed further. The grounds for arrests are also given in subsection 1, where it talks about the police officer must have a reasonable ground. So he just cannot go back and do it, which is unreasonable, for believing that the individual has committed the offense or will commit further an offense. So this belief must be stem from credible information, evidence, or his evaluation of the situation. So the arrest is then, why the arrest is necessary? As I said, it is necessary to prevent any further offenses or further continuation of the offenses. Then second thing is, as the offense has happened and there is a strong reason behind that, then to ensure a proper investigation also this arrest is required. Then to prevent the evidence tampering. So subsection 1 also says why you will arrest is also to prevent evidence tampering. Somebody might tamper the evidence. If somebody is selling a drug and the police officer comes across that, or through any information or suspicion, the person is grabbed, arrested. So what if the person immediately disposes the drugs into the nearby drainage and runs away, and goes and takes a shower? So that is why it is very, very important in that scenario also to prevent the evidence tampering. The person has to be arrested, or somebody caught with red-handed during a theft or a murder, etc., etc. Then the other reason why the arrest is made is dissuade any interference with the witness testimony. So this might be a reason where somebody might be tampering or bothering the witness, and that has to be also guaranteed by such an action. And it also guarantees, the arrest is also guaranteed to ensure the individual's arrest also in terms of bringing him for attendance in the court. So for all such reasons, subsection 1, which registers these reasons, the arrest has to be made, and the police officer must document the reason for the arrest in writing upon making the arrest. If the arrest is made, a written reason has to be made. Now, notice for non-arrest situation, which is subsection 3. If the police officer determines that the arrest is not necessary at the moment, they must issue a notice requiring the individual to appear before them. And this new notice will include the nature of the allegation, what is against that person, and direction for the individual to comply with. So, where you have to appear, when you have to appear, and to understand the legal obligation they are going to have. Now, compliance and consequences are listed in subsection 4 and 5, where it says the individuals who receive a notice are required to comply with the terms. Now, if the person complies and continues to meet the terms or condition, they will not be arrested. Under the police officer's record, if everything is being done, no problem, the person will not be arrested. But if there is a reason for believing that the arrest is possible and justified at any point of time, the police officer may, with an order of the court, arrest the person also. And if the individual does not comply with the notice or refuses to identify themselves, then the police officer can arrest them, provided that this is in accordance with relevant court orders. So if there is a court order has to be obtained still in that case. If the compliance happen and then the police officer has a suspicion, needs to be arrested with an order of the court, still the person could be arrested. And if not complying, of course, with the order of the court, the person can be arrested. Subsection 7 talks about the special consideration for vulnerable population, which is the people who are infirm, etc., which is mentioned there, and who have committed a crime which is punishable for less than 3 years. So in those cases, there is a supervision which has been added from the senior officials, and that is why it cannot be proceeded, without that. So all these people who are old, get more than 60 years old or infirm, they cannot be arrested that way. So what is the purpose of this section is this guarantees an immediate police action. If the person is authorized as a police officer to arrest without warrant, which means he can arrest without a warrant and he can immediately, a police action can happen, which is a very, very important aspect of the policing. Then the rights of the individuals at every stage also has been guaranteed by the provision, including the special consideration to the vulnerable people. And then oversight is also added through the magistrate and the senior police officer. So this is about section 35. Let's move to section 36, procedure of arrest and duties of the officer making arrest. Now, if arrest is happening, in that case, what is the procedure of arrest and duties of the officer making the arrest? So every police officer, while making an arrest, shall, number one, bear an accurate, visible, and clear identification of his name, which will facilitate easy identification. So this is, as last time also I said, this is from both the perspective important, because the police officer also by default are supposed to reflect their names on the badges, but it is also very, very important in these cases where the person is also identified well, because there have been cases of mistaken identity and arrest. They have to generate a memorandum of arrest which shall be attested by at least one witness who is member of the family or the person arrested or a respectable member of the locality where the arrest is made, which we normally call the punch. It has to be countersigned by the person arrested. The person has to sign it and inform the person arrested unless the memorandum is attested by a member of the family that he has a right to have a relative or a friend who can uh, they can come and uh, help him for his reason of arrest. So what is 36? 36 talks about the, first of all, identification. So it has to be very clear identification in case of the officer that the person who is arresting. That also helps to ensure that there is a fairness and there is nobody who is no police officer and a fake person can come and do an arrest. So identification is very, very important. This also gives an accountability to the police officer, because if you're known and then you are part of some action, then you are named into the accountability. And then this is also very important from the perspective of the correct identification of the person whom you are arresting. You are arresting whom you are supposed to arrest. Now, memorandum of arrest subsection B talks about that. So the police officer must prepare a memorandum of arrest, which serves as a formal record of the arrest process. Although the courts have been always grieving about the memorandum of the arrest, because it's more over a mechanical, because there is a lot of things people police have to add into that. It's mostly a very mechanical thing what the police do, but then the procedure actually allows them to do it very diligently. And then when you making a memorandum, it has to be definitely witnessed by somebody. So either a family member who might be have a reason to ensure things are fair, or a respectable member of the community who can come and sign on behalf, and then the arrest has to happen. And it has to be countersigned by the person, so that the person knows what exactly has been written there and what are his rights against the arrest. So the person has to affix his stamp or thumbprint. Information to the arrest person has to be definitely given as subsection C, because it is everybody's right to go ahead and have a proper means or possibility to uh, challenge the allegations, whatever is against them. And this brings in transparency to protect the accused's rights as well. So what is the practical implication of section 36 is it is an accountability which is added with the police officer from the identification perspective. Protection of the rights is done by ensuring that in the memorandum what is going in is supposed to go in and is correct and not something which is fake, and which is attested by either somebody from the family or somebody who is a respectable citizen or the accused also is given a chance in that case to have at least one person from his friend and family, and the person has to right to know what exactly is going in the memorandum against him, the whatever has been found and recorded, and the person also has a clear understanding of what is in the memorandum by fixing his signature or thumbprint when somebody reads it for him, or if he's capable to read. So this also brings a transparency in the procedure so that there cannot be a counter allegation about something being done out of malice intentions. It is a protection also from that kind of defense. Now, let's go to section 37, designated police officer. So the state government shall, number A, establish a police control room in every district and a state level and at state level. Number B, designate a police officer in every district and in every police station not below the rank of a assistant sub inspector ASI of the police, who shall be responsible for maintaining the information about the names and address of the persons arrested, nature of the offense with which charged, and which shall be prominently displayed in the manner including in digital mode in every police station and at the district headquarters. So this is also an aspect which doesn't only gives a clarity that way to the family and the friends of the accused, but it is also from human right perspective, because it is every person in the country who is being arrested or contained in some place has to be accounted for. So nobody should be confined secretly until and unless it is very much required by some law, some process, some kind of special action. But in general, there should be a designated police officer in every district and in every police station who is not below the rank of a assistant sub inspector, so ASI, and who will be responsible to maintain the information of the whoever is arrested and from what address and what particular offenses, etc., etc. And that has to be listed online also, and that has to be also displayed in the manner in the police station also. So if you ever go to the police station, those lists of number of people arrested, the empirical numbers are always mentioned there. And you see if you go to the Pune police or the Pimpri police online or many other polices in India, there is a provision in the Pune police and Pimpri police also where you can see whoever is arrested, how many arrests have been made in which police station, and what are the things which are lost and found, and which dead bodies are found, in unidentified bodies, etc. So all those details are made uh, available online also nowadays. So what is this section doing is, this section is establishing a police control room. So basically a police control room was mandated, and for the same reason, for creating a accountability of people who are arrested to be known. So it mandates the state government to establish a police control room at both the district and the state level. So district level, it will end of the day summarize to the state level. So these control rooms serve as a centralized hub for monitoring and managing police activities, operations, and communications. So they manage centrally the activity, operation, and communication. Now, what is the purpose? So this is intended to enhance the communication coordination among various police units, first of all, providing a streamlined system for addressing public safety concerns and improving the efficiency of law enforcement operations, and also giving a transparency from human right perspective where every person, his or her records are also available online so that people could know that that person is in the custody of the police. Designation of a responsible officer is mentioned in subsection B, which is somebody who is not less than the rank of a ASI, Assistant Sub Inspector, who will do this reporting on daily basis. It has to be made available at the police station local level and all the possible levels, and digitally also it has to be available, and it has to be summarized at the state level as well. Then we talk about the responsibilities of the designated officer. So the person, what is his responsibility? What are the responsibilities of this person? So the responsibilities of the person is the record keeping. Very first thing, the person has to make a record of all these people who are arrested, their addresses, and what offenses under which they are arrested. Then the person has to ensure there is a transparency so that the information which is critical for the police operation and for the people in general is available, and a public access also has to be enabled by the person where the public can look into the district headquarters, etc., etc., the details displayed on the display system. So this section, what it does is it enhances the coordination, it enhances the accountability and oversight, and accounting for the people who are in custody of the police, and increase a police awareness as well. And there is a special officer who is helping in that, which is the person who is at the rank of not less than at the rank of ASI, and that person is responsible to be as a designated police officer. Then let's move to section 38, which is right of arrested person to meet an advocate of his choice during interrogation. Now, this is a little dicey. It's a very small section, but its implication and its interpretation may vary a lot. So, when any person is arrested and interrogated by the police, so somebody is arrested and interrogated by the police, he shall be entitled to meet an advocate of his choice during interrogation, thou not throughout the interrogation. So, not throughout the interrogation. Now, this is a very, very key part, which is reflecting by the last part of the section. So, the first part of the section clearly says, yes, you have a right and entitlement to meet an advocate of your choice during the interrogation. But it's not something which is completely open. It has to be used cautiously, and it has to be provided also cautiously. So it cannot happen across the interrogation. When the person has initially been brought in for the interrogation, at that point of time, when the police will come back and talk about those charges against him and those allegations against him, at that point of time, he will have an access to the advocate where the necessary signatures, etc., could be taken, the wakalatnama, etc., could be signed, etc., and the first level story could be understood by the advocate for defending the person later in the court also, because advocates will not go back and defend a person in the police station. That is not our ground. So our ground of play is the courts. So that is where the person is available. And then in between, whenever the police feels that person could be made available, the person could be made available. But then for the satisfaction of the advocate can be somebody who can keep an eye on the health and uh, other aspects of the accused as well. So this is something which is not a blind right given to you, which is something which is available across the interrogation, because there might be some areas of interrogation where police might get into some sensitive discussions, or maybe the person would be exposed to some sensitive information, etc., etc., and which might not be required to go out of that room of the interrogation, and those places where police might avoid him to reach out and meet anybody. So there is a right of legal representation which is given by this section. Which section talks about right of legal representation. Everybody has got a right of a legal representation. We are a country, proudly we also follow the process up to the teeth, that even if we catch a terrorist, then also we ensure that we are following the proper legal procedure and we are not just blindly doing anything which looks odd. So the person who is arrested have the fundamental rights which has to be consulted. And as I mentioned earlier in one of the sessions also, all the fundamental rights, etc., etc., which are given by the Constitution to the people who are standing on this soil of India, who are content in these geographies of India, who are part of the people who are currently present in the India. It has nothing to do with the citizenship. So the fundamental right to consult with an advocate is given through this section, which is a very big right to ensure that the interrogation process, the person has somebody to take care and give a firm and formal support. So this provision acknowledges a very important of legal representation importance, legal importance of the legal representation in protecting the right of the accused. So, which is very, very important. Now, entitlement during the interrogation is given here, that the right to meet with an advocate is specifically tied to the investigation phase, what phase it is into. So this means that while the arrested person can request and be entitled to consult their lawyer, the right is not unlimited. It is not unlimited, right? And it cannot be. It is applicable only during specific moments of the interrogation as determined by the police, specific windows it will be available. And these are the small things which will make you understand the law better and practice it better. So what is the implication? The implication shows that the accused has uh, to receive a legal guidance and advice while interacting with the law enforcement, but to reinforce their right, but this is not ultimate right. This is not unlimited right. Why? Because if it has to be, if what happens, let's do a scientific way of discussion where we put some assumptions, theories, and then we do a statistical analysis to understand, interpret the result. So in the very same way, if we go back and say, okay, fine, if let's make it completely available across during the interrogation, then it will fail the purpose of the interrogation, because interrogations are primary subject of the people who are affected, the police officer and the person who is accused to have caused that criminal offense. In that case, any third person will only dilute or disturb the interrogation. It might delay it, it might completely overturn it from the right track. And that is why, for the sake of a healthy interrogation also, it is not possible. So what we can give is only partial access. But why partial access again? Why not no access at all? Now let's think from the other perspective. Then it is something which is a violation of the human rights of the person, the fundamental rights of the person to have a legal representation. So this is why the balance of interest is there. So limitation seeks to balance the right of the accused with the operational need of the law enforcement. Both has to be balanced. And this allows a effective interrogation also, while also taking care of the rights of the individual also. And that is why it is not allowed in all the phases, but in the windows where it is uh, during the interrogation. So what are the practical implications of this particular section is, this is something which is fair in makes the trial and the inquiry, investigation, etc., a fair trial, with the accused also getting right appropriate chance, and it is also safeguarding against any coercion to the accused by the police officers or the law enforcement agencies, while it still strengthens the legal uh, in the investigation of the police officer, while in hand going with strengthening the legal defense of the accused also. So he also gets an equally potent and strong way and method to go and defend his case as well. So this is about section 38. Let's move to section 39, which is titled as Arrest on Refusal to Give Name and Residence. So when any person who in the presence of a police officer has committed or has been accused of committing a non-cognizable offense, we are talking about non-cognizable offense, be very clear on this. Because in non-cognizable offenses, the thumb rule is, the baseline is, the person cannot be arrested without a warrant from the order of a or order from a court. We have studied yesterday also something that in those cases when it's a cognizable FIR for a cognizable offense is written or a complaint is received, there is a bar on the investigation of the police until and unless any magistrate is allowing to do that. So that is why it is the person who is in presence of a police officer. So in design of the same, as we talk about the cognizable offenses, the person has committed a or is alleged to commit something, non-cognizable offense, refuses on demand of such officer to give his names. Now, the person has actually committed a non-cognizable offense, but he is not giving his name and residence, or gives a name or residence which such officer has reason to believe to be false. So either he is not giving at all, or it seems to be false on a quick due diligence or by the experience of the officer also. He may then be arrested by the officer in order that his name or residence may be ascertained. Why this is required? Because in spite of having a non-cognizable offense, when the records are made in the police station, it is still a first information report, FIR, in the non-cognizable offense, which means it cannot be headless until and unless there is a situation where the person against whom the complaint is an unidentified person or somebody who could not be ascertained at all, for example, in case of cyber crimes, then it is fine. But in the presence of the police officer, if the person is considering doing a non-cognizable offense, then the officer will come back and intervene. If the complaint will be made formally, when the complaint has to be made formally and the person is not disclosing his name and address, then the person has to be in the custody until that is ascertained, so that the investigation later, if required by the magistrate to arrest, etc., has to be done not to an headless case. It has to be against someone. Otherwise, it destroys the purpose in spite of being having in front of the police officer. So when the true name and the residence of such person have been ascertained, now the person is arrested and kept in the police station, and a true name and the residence of person has been ascertained. He comes with an Aadhaar card, PAN card, and then he is also bringing his neighbors, and a police of marshal can go, Amaldar can go, and the person he verifies, okay, this is the correct. He's the same person. His address is same. He shall be released on a bond of bail. But now, as you are arrested, then the release is based upon bail bond, because your conduct has been so that you have a chance of not coming back to the police or to the any other such magistrate later, where you might be called for because you've done that mischief earlier. So that bond or bail bond has to be done to release that person and to appear before a magistrate if so required, provided that if such person is not resident in India, the bail bond shall be done by a surety or sureties in India. So if you are, as I said, these rights are given to anybody and everybody who is standing on the soils of India. It could be a foreigner also, or maybe an Indian who became an NRI. In that case, the sureties has to come from somebody in India who will compel your presence whenever it is required. The subsection 3 talks about if the true name and residence of such person is not ascertained within 24 hours from the time of arrest, or if he fails to execute the bond or bail bond, or if so required to furnish sufficient securities, he shall forthwith be forwarded to the nearest magistrate having jurisdiction. In that case, this is same as we do for a arrest without warrant. So any arrest without warrant also, the with all the reports and the information, the police has to forward the person to the magistrate. So that is why they say in 24 hours, if the police is not able to find that person's whereabouts and name, then the person has to be and person is not ready to execute a bail bond, etc. Also, then if required to furnish sufficient securities, also the person is not enabled, then he shall forthwith be forwarded to the nearest. So the person will be arrested and presented to the magistrate, because the police works on a small scope of reasoning of identify things and a very small level of discretion to decide black and white. But to take any judgment on what has to be done further is something which is not in the role of an executor, because they're executor, it will has to come to the judiciary. And that is why they have to now send it to the magistrate to get the further orders on will that person be released, or the person needs to be sent to judicial custody, or the any such kind of fine, etc., has to be done and the person is to be released, whatever. So this is something which is talking about the authority of arrest. What we're talking about is authority of arrest in case of a non-cognizable offense. So this is a specific case, specific flavor of discussion where we talk about the non-cognizable offense condition. So subsection 1 says, what are the conditions for the arrest? If the individual refuses to disclose the name and residence when requested, so the person cannot be identified or traced after that, and the individual provided a name or residence that officer believes to be false. So the provision is important to maintain order and accountability. Otherwise, accountability of that particular crime or offense will be on whom? Subsection 2 talks about confirmation of identity. So once the true name and the residence of the person is known, then the person is released on after executing a bond or bail bond with surety, etc. before a magistrate, and this allows individual for regain their freedom once their identity is confirmed. And special consideration for non-resident is they have to receive sureties and bail bond from people who are staying in India, which is allowed, and forwarding to the magistrate. If the police cannot ascertain the true name residence within 24 hours, they are not able to do it. Then the individual fails to execute the required bond also. So either of the case, then they must promptly forward the person to the nearest magistrate who has jurisdiction. Now, this procedure ensures that the individual who are unable to confirm their identity are not held indefinitely and received appropriate judicial oversight with a reasonable time frame. Because if there is no time frame of 24 hours drawn there, what would be the time period the person would have been in the police station? This is in line with the 24 hours of being in the police station before the person has to be presented to magistrate. So in case of a non-cognizable offense, even if only for the purpose of ascertaining the ID and address of the person, if you're doing that, then also you only have a time period of 24 hours for doing everything. Otherwise, you bring that person to the magistrate for the any further orders on what has to be done. Now, please understand this magistrate could be somebody from the jurisdiction wise in that jurisdiction, or if required, uh, it and urgently it is required, it might be to a magistrate who does not have a jurisdiction also for taking a decision on if the person uh, could be kept for a few more hours or a day or two for ascertaining the address, or what else the magistrate will do is they will forward it to the right magistrate. So the practical implication is it empowers the law enforcement that a necessary tool of to maintain the order and ID verification is there, and safeguards the right of the accused by while uh, giving him those benefits that when it is ascertained the person will release, but it ensures the compliance also. So it has got in one hand uh, a bouquet for the accused, on the other hand it has got a stick for compliance as well. So this is section 39. Let's move forward now to section 40, which is arrest by private person and procedure on such arrest. So we spoke about the procedure of the arrest by the police officer. We spoke about cognizable, non-cognizable offenses situations as well. Now we see section 40, which is arrest by a private person and procedure for such arrest. So if you're a private person and somehow you have received a warrant for arrest, so any private person may arrest or cause to be arrested. So you can take help also. Cause to be arrested, any person who is in presence commits a non-bailable and cognizable offense. So it has to be a non-bailable and cognizable offense if that is being happening, or any proclaimed offender. The offender which is proclamation means a formal announcement. So the person is known to be an offender. So that is a proclaimed offender. And without unnecessary delay, but within 6 hours from such arrest, shall make over or cause to be make over any persons arrested to a police officer, or in the absence of a police officer, take such person or cause him to take into custody to the nearest police station. Now, we have read this section earlier as well. What is important is there is a timeline also is attached now, which is within 6 hours you have to hand it over, because in in absence of such a guidance, it is very difficult at times to justify that if the person who was arrested was kept reasonably until some timeline with the private people, or it has been done with as per the due process of the law and sent to the police officer or police station in time. Subsection 2 says if there is reason to believe that such person comes under the provision of subsection 1 of section 35, a police officer shall take him in custody. So if the person comes under subsection 1 of section 35, the police officer shall take him in custody. So which means if the person is somebody who is committed a cognizable offense and where the police officer can arrest that person without a warrant. Subsection 3 says if there is a reason to believe that he has committed a non-cognizable offense. So the people who have arrested might have arrested believing he has considered a non-bearable offense and cognizable offense for whatever reason of negligence, or maybe because of some kind of uh, some kind of malice intention or whatever it is, if the person is brought to the police officer or police station, and in that case, if the person, subsection 2 says, is the police officer is believing that reasonably that the person has committed a cognizable offense, which is some offense which is also non-bailable, the arrest will be happening quickly, immediately. But if when the validation by the police officer, the officer understands that the person has committed a non-cognizable offense actually, and has refused on the demand of the police officer to give his name and residence, then again the person, until and unless, as per section 39, what we studied before that, has to be dealt with. But if there is no sufficient reason to believe that he has committed any offense, he shall be at once released. So, in case if the person has committed a non cognizable offense, the person has to be immediately released until and unless the person is resisting to give his name and address, because the person has to give a name and address. So what it talks about is authority to arrest by a private individual, which is in subsection 1 talks about that a non-bailable and non-cognizable offense only are there under which the person can arrest somebody, a private person can arrest somebody or make it happen, and but they have to hand over the person within 6 hours to a police officer or a police station nearby. So that is something which can be non-bailable, and cognizable offences are basically offences where arrest can be made under section 35 by the police without having a warrant. But it is also known that the public might at large may miss also and not understand properly any offense also at the be it billable, not billable, etc. So it also says procedure following the arrest. So following the arrest, by the private person, 6 hours you have to hand over, and importance of 6 hours is very, very important. Okay, little bit here and there is fine, but it has to become swiftly. Police custody conditions are also given in subsection 2, where it talks about if the private individual believes that the person arrested it finds the fits the criteria given in section 35(1) with arrest with warrant, then the person, even if that is believed by the police officer, would be arrested immediately. And non-cognizable offences also, it is handled as per section 39. If it is non-NC, then the person will be released at once by recording all the information on the paper with adding his name and address. If the person is failing to do that, then we follow the processes given in section 39 about how the person has to be, if the person has to be arrested, kept for 24 hours at least to ensure the name address could be recovered. If it still doesn't happen, within 24 hours, the person will have to be brought to a magistrate, and then the order from magistrate will decide the fate of the person. So it encourages an active citizen partnership, because a citizen can also participate in the crime management at their level up to whatever is possible, and that is what is motivated and aligned by section 40 safeguarding right. So the emphasis is returning the arrested person to police officers within a specific timeline is something which is a right of rights are respected of the accused as well, and they are not unlawfully detained by the private person. So if it goes beyond that, what will happen? The law says any detention of anybody which is unreasonable is called a for without any right reasons is a detention, unlawful detention. So that is why it was very, very important to put a timeline to ensure that there is a measurement or a indicator available which says if it is a unlawful detention or it is not. And it, by giving all the bifurcations and different conditions, it talks about the clarity in the legal perspective is also given. So that's about section 40. Let's move to section 41, which is arrest by a magistrate. Now we talked about the police, we talked about the common people, now we talk about the magistrate. So when subsection 1 says, when an offense is committed in the presence of a magistrate, what was 35? In presence of a police officer. So, and 40 was in presence of a citizen. 41 talks about when an offense is committed in presence of a magistrate, whether executive or judicial. doesn't matter, within his local jurisdiction, within their own jurisdiction, he may himself arrest. So, if possible, the person will arrest himself or under order any person to arrest the offender and may thereupon subject to the provision herein contained as to bail commit the offender to custody. Subsection 2 says any magistrate, whether executive or judicial, either of them, may at any time arrest or direct the arrest of his in his presence within his local jurisdiction of any person for whose arrest he is competent to, and the time and in the circumstances to issue a warrant is also has to be recorded. So what it talks about the section is authority of magistrate to arrest. So of course, if a common person has an authority, magistrate will also have. So it could be, it is given to both the executive and the judicial magistrates, but it has to be, they have authority to arrest when offenses is committed under this section. We talk about the offenses which is committed in their presence, and it is also be happening in their own jurisdiction, and they can have an immediate action and they can make an arrest happen. Now, subsection 1 also says circumstances for arrest. On what circumstances the arrest could be made. So, it could be presence during the offense. If the magistrate is present during the offense and somebody who has witnessed that, this is a circumstances for arrest which could be happening, or commitment to custody. So, if the once an arrest is made and the magistrate has the authority to then commit the offender to custody and ensure that the individual is held accountable for their actions in accordance to with the legal procedure, and the commitment is subject to relevant bail provision. So if it is bailable, non-bailable, etc., etc., and which ensure a bail obtained or not, or a bail cancelled or not. So which ensures that if the offense is bailable, the accused may be released under certain conditions of bonds, etc. Then subsection 2 talks about the general authority of the magistrate. So this subsection extends that the power of the magistrate to direct the arrest of individuals within their jurisdiction under circumstances that would justify issuing a warrant for the arrest, and this includes the warrant issuance competence. So if the person is capable of issuing certain kind of warrants, and they are able to issue such warrants, and they have that competence for all those matters for which they can raise a warrant issue, what when they can do for all those things, the person can make an arrest also. And this is going to something which is empowers at the level of magistrate also to maintain a public order and safety, and they are also empowered to do the same thing. So by having put magistrate acting in their presence, if they see something happening, it is a very swift justice which can happen, and definitely automatically and interestingly under the supervision of a judicial oversight. The last section in no, not last, 42nd section is protection of members of armed force from arrest, which we have been seeing across all the chapters when we study all the relevant areas, that the government officials are protected up to the level where they have to bring their own response and report from their senior officials. Similarly, way the members of the armed forces are also protected from arrest. Now, notwithstanding anything contained in section 35 and section 39 to 41, both inclusive, no member of the armed force of the Union shall be arrested for anything done or purported to be done by him in the discharge of his official duties, except after obtaining the consent of the central government. So, without except under consent from the central government, no person can be arrested in line of their duty. So, in the discharge of their duty, they are exempted, they are protected. So subsection 2 says the state government may, by notification, direct that the provision of subsection 1, which is the immunity to the union forces until and unless there is a consent from the central government, shall apply to such class or category of the members of the force charges with a maintenance of public order as may be specified therein, wherever they may be serving, and thereupon the provisions of the subsection shall apply as if for the expression central government occurring then there in the expression state government were substituted. So in those cases where when we talk about the um, category of the members of the forces, etc., at the state level, you read it as it is written for the state government by replacing the word mentally from central government to state government. So this is a special protection to armed forces which is given under this section, and it is clearly said that uh, there is a protection of the members of the armed forces of the union against arrest for action taken to the in the course of their official duty, and the provision recognizes the origin unique role. It's a very unique role of military personnel in uh, executing their functions. So the arrest is something which is they are immune to. What is the requirement of government? Consent is they have to have a member of the armed forces cannot be arrested for acts done in the discharge of the official duties unless prior consent is obtained from the central government. So even if you have to arrest somebody, you have to need a consent from the central government, and this is how they are protected. So this protection is applicable, but is it applicable to the person or the person during their duties? So it is both. So it is something which is applicable to the action performed as part of their official duties, and for those actions they are protected. So thus there is an accountability while safeguarding those serve in defense of the nations. They are somebody who are doing in the line of the duty something. In that case, they are protected. And why they're protected? They're protected for the letting them execute those things which they are supposed to do so that it is in interest of the nation. State government's authority then is talked about in say, subsection 2, which says extension of the protection happens in the state government may issue notification to extend the protection to specific classes or categories of armed forces which are responsible for maintaining public order regardless of the service location. So it doesn't matter if there is a service location within the state also, it is extended there. This allows for flexibility in how protections are applied that ensure that various states forces enjoy similar safeguards. So in those cases, it is the written wordings are not changed, but it is said that it is in that context when we talk about the state forces, read the word state government instead of the term, read the word central government instead of the word state government. So the when the state government specifies, then so and so category of personnel are included from the state, then the term central government within the context of this section will be interpreted as the state government. So when you are applying it to the state forces, same particular section will be then read to be for the state instead of the central government. So it gives an judicial oversight. It prevents a misuse of authority. It brings in a clarity in the military and the civil relations. Now, section 43 is about arrests, how made. So how the arrests are made. So in making an arrest, the police officer or other person making the same shall actually touch or confine the body of the person to be arrested. So the person has to be touched and the body has to be confined, has to be put somewhere safely, unless there be a submission to the custody by word or action. So if there is a submission to the custody by word or action, it is said and the action happens, then it is not required. Provided that where a woman is to be arrested, unless the circumstances indicate to the contrary, her submission to custody on an oral intimation of arrest shall be presumed, and unless the circumstances otherwise require, or unless the police officer is a female, the police officer shall not touch the person of the woman for making her arrest. So they are protected by this, the women. Now, if such a person, subsection 2 says, if such a person forcibly resists the endeavor to arrest him, so if this person is forcibly trying to escape or attempts to evade the arrest, or they have run away to evade the arrest, such police officer or other persons may use all means necessary to effect the arrest. Subsection 3 says the police officer may, keeping in view the nature and gravity of the offense, use handcuff while making the arrest of a person or while producing such person before the court who is a habitual or repeated offender, or who escaped from custody, or who has committed offense or organized crime, terrorist act, etc., drug related crime, any illegal possession of arm, etc., and ammunition, murder, rape, attack, counterfeiting of coin, currency note, human trafficking, sexual offences, crime against children, offences against the state, etc. The officer may keep in view these people might be handcuffed also if required, depending upon what kind of crime they have done. And subsection 4 says nothing in the section gives a right to cause the death of a person who is not accused of uh, offense punishable with death or with imprisonment of life. So nothing in this section gives a right to cause the death of a person who is not accused of any crime which is punishable by death or imprisonment of life. So that is something which is a right. Nothing in this section gives a right to the cause the death of a person. So why the person this condition is made? Because these are the people for imprisonment for life and one, offense punishable with death. They are people who have committed some maybe a very heinous crime or a very big crime. So in those cases, it is far more important to curb the crime than to get the person and get him tried. So any cost, the person should not be out of the clutches of the law. Subsection 5, which is the last subsection in this section 43, is that save in exceptional circumstances, no woman shall be arrested after sunset and before sunrise, and where such exceptional circumstances exist, the woman police officer shall, by making a written report, obtain the prior permission of magistrate of the first class within whose local jurisdiction the offence is committed or the arrest is to be made. So, sunrise, sunset, it is not allowed, and when such exceptional circumstances exist, where it has to be done between sunset and sunrise, the woman police officer shall, by making a written report, obtain the prior permission from the magistrate. So, even a woman police officer cannot arrest somebody without a permission from the magistrate in the night. A woman also cannot arrest a woman in the night until and unless there is a magistrate order available. That too from a JMFC to be minimum. And that too from the same jurisdiction where the offense is committed. So what is this talking about? This is talking about the procedure of making an arrest, which is given in subsection 1. It says the fundamental procedure that a police officer must follow is when making an arrest is emphasizing the need for physical interaction unless the individual voluntarily submits to the arrest. So it has to be done physically. Physical touch requirement is also there, where the officer must physically touch or confine the individual being arrested until and unless they agree to take this this custody, either verbally or in their action. Now, special provision for women is also given that the lady cannot be arrested before sunrise and after sunset. And no physical contact has to be used unless the circumstances dictate that. So that is also something which is for the ladies. Use of reasonable force is something which is given. So when you put a handcuff and when you tie somebody, you should ensure that it is reasonable. It just cannot be too difficult and too much for somebody who does not need that kind of treatment. Then use of handcuff is given during the cases involving habitual repeated offences, individual who have previously escaped custody, and serious offences such as so and so crime, which I mentioned earlier. So this approach helps to manage a potentially dangerous situation and ensure that the safety of both officer who are public during arrest involving their serious allegations. So limitation on use of deadly force is also given under subsection 4, where it says the section clearly says the police officer has do not have a right to cause a death of an individual unless that person is accused of an offense punishable by death or life imprisonment. But this is also a difficult situation because that has to be clearly reasoned out by the police officer if the death is being caused. And in case if he or she is not able to prove that, then it's a difficulty for them for life. So this arrest to uphold the value of human life and emphasizes the need for lawful conduct by the law enforcement officials. And it does protects the right of accused. Let's move to section 44 now, which is search of place entered by police sought to be arrested. So section 44 subsection 1 says, if a person acting under a warrant or arrest or any police officer having authority to arrest has reasons to believe that the person to be arrested has entered into or is within any place, and any person residing in or being in charge of such place shall, on demand of such person acting as aforesaid or such police officer, allow him free ingress thereto and afford all reasonable facilities for a such there. So the police, any person who is acting under a warrant or a police officer, because both have similar rights except the right of arresting without warrant, the commoners do not have that. So when they have a strong reason to believe that the person whom they are going to arrest has entered into some premises or is within some premises or any place, and the any other person who is in charge for the access of that person or maintenance of that person who can make the access happen shall demand such person that such police officer that this they have to be allowed to a free ingress in that place, a free entry in the place, and afford all reasonable facilities for the search therein. So they can then conduct a search within there. Subsection 2 says, if ingress is to in such place cannot be obtained under subsection 1, it shall be lawful in any case for a person acting under a warrant, and in any case with a warrant may issue, but cannot be obtained without affording that person to be arrested or opportunity of escape for a police officer to enter such place and such herein, and to order to effect to entrance into such place to break open any uh, outer or inner door, etc., or window of any house or place, whether that of the person to be arrested or of any other person, if the effect the if the after notification of the authority and purpose and demand of the admittance duly made, the he cannot otherwise obtain admittance. So provided that in such places is an apartment in the actual occupancy of a female, not being the person to be arrested, who according to custody does not appear in public, such person or police officer shall, before entering such apartment, give notice to such females that she is in at a liberty to withdraw, and shall afford her every reasonable facility for withdrawing, and may then break upon the apartment and enter it. So subsection 2 talks about then uh, if they have to break open and enter, they can do it for the reason of either entering or coming out. And if there is a probably a reason where the person is a lady who is in that place, who is a custom, does not appear in public, then the person or the police officer shall before entering such apartment give notice to that lady that she has the liberty to withdraw, and shall afford her every reasonable facility for withdrawing, and may then break open the apartment and enter it. The police officer or other, so if you see in the law, it is always in all the sections, whatever we have read until now, whether it is for accused, whether it is for magistrate, whether it's for a person who is a victim, each and every place, there is a provision of a prior consent of the person or a prior intimation to the person by which the fairness is established. So, in every such sections, acts, etc., you will see the same. For example, in the traffic management, if you see the people come in truck and they pick up the scooters or they tow the cars. Although you don't see the exact procedure happening, but the exact procedure, if you're a lawyer, you will come back and know, and you can challenge is they have to come with a speaker, they have to make an announcement. We are going to pick up the scooters from here, we are going to pick up the bikes from here, give 5 minutes of opportunity for people to take it away, and then they can pick up the vehicles. So if go by teeth, everything, the law, then in that case, it is something, in always it is given a fair chance by the procedures, which is mentioned here also. Subsection 3 says any police officer or other person authorized to make an arrest may break upon any outer inner door to or window of house in place order to liberate himself. So if they are gone inside and got trapped, they can liberate themselves. Or any other person who having lawfully entered for the purpose for making an arrest is detained therein. So if somebody is detained also, to take them out, it can be done. So authority to search for arrested person is something given in subsection 1, and this is an extension where you want to arrest somebody and you reasonably believe that the person who has to be arrested has entered into this premises. So section 44 talks about that. And there is an obligation of the people who are owning that premises or allowing the access out to the premises to give you an ingress. So if it is not happening, then the subsection 2 talks about the enforcement of the entry. So if access to the location is denied, you can break and enter. And special consideration for women is given, where if it involves a space where there is an occupied by a woman or women who are not in person to be arrested, they are not the people you are going to arrest, and who, according to custom, does not appear in public. It's customary for them to not appear in front of the public. The officers must definitely inform her that she has the option to withdraw before entering the premises. So she can withdraw herself from the premises. And this requirement promotes respect for the privacy and dignity, particularly regarding females, witness, or resident. So she has an option to withdraw. Of course, if she is the person who has to be arrested, you will not give this notice. Liberty to break and enter is given in subsection 3, where it is lawful to do that forcible entry by opening inner, outer doors, window, etc. And it is also liberty to break and go out in case they are trapped inside and they want to free themselves. So it gives an effective law enforcement even within the premises if the person is hiding himself, who is supposed to be arrested. It also balances the right of the police power and gives a special power to break into also in case if they have to. And any obstruction which has to be there to be removed, they can remove that obstruction. But parallelly, they're also giving a value to the various customs, etc., to ensure that those are also respected. And the power of removing obstruction is also not given there. It is also given a power to liberate themselves, and if they find somebody who is illegally detained in that premises, they can also liberate that person forcibly by breaking doors, windows, etc., and coming out. So this is section 44. Now section 45, pursuit of offenders into other jurisdiction. So a police officer may, for the purpose of arresting without warrant, any person whom he is authorized to arrest, pursue such person into any place in India. So they can go and arrest anybody for the purpose of arresting without warrant, which is a cognizable and non-bailable offenses. So it is an authority to pursue across jurisdiction. There is no bar with that. And they have an authority, the police officer, to pursue the offenders beyond their specific jurisdiction or regional boundaries for this purpose of making an arrest. But this means that the officer can cross districts, cross state, or cross regional areas. They can cross within India to apprehend a suspect who is fleeing from the legal custody or evading an arrest. In all those cases, the police has a right. Uniformity in the law enforcement is something which happens because of that, because the national scope has happened. There is a seamless action to the police officer today. There is an uniformity in the law enforcement, irrespective of where the person has rushed to. And the conditions for pursuit is there is an authority to arrest. The police officer must be authorized to arrest the individual without a warrant, and then only this particular situation can happen. And meaning there are circumstances of existing powers as delineated in their sections, and the permit the arrest without prior judicial authorization. So if they are allowed to arrest without a warrant, in those cases they can do it, otherwise not. They cannot go out across India and try to find somebody who against whom there is no complaint or there is a non-cognizable complaint. So purpose driven, this is something which is specific for the purpose of making an arrest in connection with offense that the officer is legally empowered to arrest. If they are not legally empowered to arrest in those sections areas, or their roles and their designations are not allowing that, they cannot do that. So it increases the criminal justice scope. It brings in the coordination among the agencies, and it is something which is preventing an evasion of an accused who has committed a crime and who has evaded. So you are after the accused and not allowing them to evade from the local jurisdiction of your police station and being out of the site. They are very well in the site across the India wherever they go and reside. Section 46 talks about that there is no unnecessary restraint. So it is very clearly. So the purpose of this particular section was definitely, I mean, this is something which could have been understood implied also, that they have already mentioned partially in the person has to be not handcuffed and etc. in multiple sections. Then why this section is there? This is a clear section saying that person arrested shall not be subjected to more restraint than it is necessary to prevent his escape, which is taking care of the person's right, respect, and the human right violations. Also, they do not occur, and that is why principle of minimal restraint is being popularized and is being ordered by the section 46. So the principle of minimal restraint has to be there. So it says it is subjective on at par with what kind of crime the person has committed, what kind of the person is that, and what scenarios the person has done. The police has to apply their mind, and they have to use the principle of minimal restraint in all such arrests. Either they are taking the person to the PC, police custody, or they are taking him to a court, or they are transferring him to a jail, or they are bringing him from a jail. In any cost, the principle of minimal restraint has to be used. And when a person is arrested, the level of restraint applied must be proportional and limited to what is necessary to prevent the individual from escaping. The principle is key to ensuring that the rights of the arrested individuals are respected while maintaining effective custody. So their rights are also effective. They should not be tied in with the ropes tying both their hands, both their legs together, and they are being dragged on the street, which were the things not uncommon in the earlier times in India. So these things have changed the landscape a lot. If you go to the police stations frequently, you will see even the small pickpockets and the small criminals who are brought in there, never, not even handcuffed. They are made to sit in a corner, and even the food is served to them if the time of the lunch and dinner is there. So avoidance of an excessive force is curbed in general, and that is what is part of this section, that it has to be following a proportionality of the need of putting that restraint, that person will flee. But understand, if a person flees, then that police officer or the police officer in charge of police station is again responsible if they have miscalculated the restraint. So police have to be very careful in putting the right restraint. It is both sides. It cannot be too high, it cannot be too less. So it has to be up to the extent required to ensure that the individual does not flee. And human right perspective, of course, it's a dignity of a person to ensure that the person is treated with humanity and not tied as a cattle. So this is an implication. There are a lot of implications for this section for the law enforcement, where is an operational conduct. So this is something which establishes the operational conduct of the law enforcement police officers and other law enforcement personnel, whatever it be, to evaluate situation to determine what level is good. And it has consequences both sides. Then use of the restraint, handcuff and rope, etc., has to be done judiciously. And that is why all the specific guidelines and laws have to be listed out in the police stations accordingly. And the trainings has to be enabled in those areas. So that is why the sufficient or the relevant restraint or appropriate restraint is something which is mentioned in section 46. Now we'll go to Section 62 directly as per the syllabus. So 35 to 46 we have done. Under chapter 4, we'll go to section 62 now, where arrest to be made strictly according to Sanghita. So this law is something which is saying there cannot be any arrest. No arrest shall be made except in accordance with the provisions of this Sanghita or any other law for the time being in force providing for arrest. So any law, whatever is given, the arrest should happen exactly that way. I mean, it seems to be some to common person, it seems to be a useless section that you have made a Sanghita where you are doing it anyways following the procedures, then why there is a need of writing a section 62 saying no arrest has to be made except in accordance with the provision of the Sanghita? No, this is in eyes of a accused, in eyes of a victim, it might not seem very important, but now you see from the eyes of an accused, it is something which is mandating and it is making a person, a law enforcement officer or anybody who is making an arrest culpable of any such kind of offenses which they are doing if they are not following this. So this brings in the accountability and the penalty perspective for the law enforcement officers and the agencies to follow to the teeth the procedure, and that also from the advocate defense advocate perspective, this is something which brings in the loopholes where the arrest could be invalidated in the court. So these are the, again, from that perspective, given a right to the accused to invalidate, go ahead, if there is in any way the Sanghita is not followed and based on section 62 of BNSS, the arrest itself could be considered invalidated and the person would be released. The charges would be waived off. Probably in some cases, we have seen that in some cases recently also, the court has asked to, they have quashed the FIR and or they've quashed the charge sheet, etc., and they have asked to refile a case because the cases were not filed properly. They have also let the person out on bail because the arrest was not done properly, and in that case, the person was set on liberty, saying no person's liberty could be sacrificed just because the officers have not followed the procedures on time and in accordance with the relevant laws. So this is section 62 has a very huge implications if you're a law enforcement officer or if you're a defense lawyer trying to protect your client. So this is a legal framework for 662 is arrest, where it enshrines the principle that all arrests must be contributed under the accordance with the laws set forth in the Bharatiya Nagrik Suraksha Sanhita or any such law which talks about the way how the arrest has to be made and importance of the legal compliance. So the law enforcement authorities, just in the name of making an arrest for the sake of solving some matter, just they cannot be waived off. They cannot be waived off of the responsibilities of them following the procedure because this is meant for some reason. These are meant for ensuring that the right of both the parties are properly safeguarded, the proper documentary evidences are created, and there is a reason for action of the law enforcement agencies. And then this again is a standardized process which is given, which can be followed by each and every part of the country similarly. And it also brings an accountability to the officers. The enforcement agencies become accountable because of this. This is a huge fear for them. And this is and also being liberally aligned with any such law. It doesn't say only me. It says BNSS doesn't say only me. It says if you have any other law which in the time being, if it is being run and which is something which is somewhere defining how the arrest has to be made, then in those cases, the BNSS is being liberal to say that we accommodate that as well. Now we go to the next section series, which is section 72 to 75. So what is which is something which is 72 to 75 and 79 to 83, which is under chapter 6, which is process to compel appearance. And these sections are specifically under part B, which is warrant of arrest. So 72 to 75, 79 to 83, we talk about the warrant of arrest related sections. And section 72, the title says form of warrant of arrest and duration. So every warrant of arrest issued by a court under this Sanghita shall be in writing. which means it has to be follow the right process, the right court, right jurisdictions, and with the right presentation to the court. And if a warrant is issued by a court in writing, it has to be there in writing, and it should be signed by the presiding officer of such court and shall bear the seal of the court. So it has to be signed and sealed by the court, and every such warrant shall remain in force until it is cancelled by the court which issued it or until it is executed. So definitely a warrant has perpetual life. It has got infinite life. A warrant, when it is issued until either two of the options happen. Either it is executed. The moment for the purpose it was raised, if it is executed, it is completed. The warrant is executed, and or uh, it is then it is not in force anymore because the for action which for which it was raised, it is completed, or for some reason the court goes ahead and cancel where the court should be the court which issued it. So this is a requirement for issuing a warrant of arrest. In subsection 1, it says that it has to be a written format, it has to have a sign and signature, and it has to be in accordance with all the provisions of the Sanghita. Then it talks about the duration of the validity in subsection 2, where it says it's a perpetual. But there is a cancellation condition, two conditions. One is either if it is cancelled by the same court or it is executed. In both the cases, then the warrant is considered not in force. So it is not engaged to be executed. Of course, once it is executed, it cannot be enforced. So what is the implication to the law enforcement? The police officers and the law enforcement agencies can rely on the warrant validity to carry out arrest without concern for arbitrary time constraint, ensuring their actions are grounded in the proper legal authority. So then they have a proper liberty and authority to ensure that they do not have to bother. It is completely unpredictable in some cases if the person against whom a warrant is executed might not be immediately available. And you have seen in newspapers the cases coming in where somebody who against whom an arrest warrant was issued in 1990, 1985, that person has visited the city and the police have come to know, and then they have executed the warrant that point of time. So it doesn't matter, it's perpetual. It can, it has to be, once it is issued, it has to be executed or cancelled. There is no other way to stop it. It's a Brahmastra. So practical implication is structured legal framework is given, and it gives a protection against an arbitrary action because it has to be done with a warrant which is in force. So first of all, you need to have a warrant in hand. Then you need to have ensure that the warrant is in force also. Otherwise, when it will be condition when the even in spite of warrant you are not able to do it because the warrant was cancelled later or it was already executed to somebody. So all those cases, there is a control which is established, and it facilitates the effective law enforcement without worrying about the timeline. If somebody is at some point of time considered, the court considers the person has to be arrested, and until and unless the court does not changes its own decision of not arresting the person, it remains open perpetually for throughout the time this world is there. So section 73, now we talk about the power to direct security to be taken. So any court issuing a warrant for the arrest of any person may in its discretion direct by endorsement. What is endorsement? Writing on top of it on the warrant that if such person executes a bail bond with sufficient sureties for his attendance before the court at a specified time and thereafter until otherwise directed by the court, the officer to whom the warrant is directed shall take such security and shall release the such person from custody. So in that case, warrant is issued, warrant reaches to the person, but then there is an endorsement on it that if you pay surety and so bail bond, you can be a free person. So that the person who is executing the warrant, that officer, the person can be directed to take that security on behalf of the court and leave the person to his freedom. The endorsement shall definitely have what components it should have, the number of sureties, what is expected, the amount in which they and the person for whose arrest the warrant is issued are to be respectively bounded, and the time at which he is to attend before the court. So whenever security is taken under this section, the officer to whom the warrant is directed shall forward the bond to the court. So the copy of the bond has to be given to the at least one of the persons who are standing the surety and paying the bond, while the original will be returned to the court. It has to come back to the court that it is something which is executed in a manner where an endorsement was made to in the sake of letting that person be released on the bail bond in lieu of the bail bond or sureties as mentioned and endorsed on the particular warrant, and it was executed, and the proof of the same is the bail bond which is returned back to the same court which issued it. So it talks about the authority to direct for security by the court. So the court which is issuing that particular warrant has exercised in discretion to direct that accused. Now, again, the word discretion has come. So this is not a right of an accused. This is not right of anybody. This is a discretion of the court. So it's something which cannot be enforced or forced by anybody challenging it as a one of their right. So it is a discretion of the court. If they want, they can do it. So accused may be released from a custody upon executing a bail bond with adequate sureties. The person can give a bail bond and with adequate sureties, and this provides opportunity for the accused to regain their freedom while ensuring they appear before the court. The conditions for the release given in subsection 1 talks about the bail bond requirement, that they must provide a bail bond, and which is a written agreement guaranteeing their appearance in the court at respective specified times whenever it comes, and the bond must also include sufficient sureties such as additional individuals who agree to be responsible for ensuring the accused and his appearance whenever it is required. So those people ensure. So that is why they are called sureties. But again, this talks about subsection 1 talks about it's a discretionary power of the court. So the court's endorsement on the warrant allows for a flexibility. It's a flexibility given, and it is something which is creates an accountability, but this is a pure discretion of the court. Subsection 2 talks about the specifics of the endorsements, which is a number of surety has to be then, bond amount, when the attendance is required, etc., etc. And forwarding the bond is subsection 3, which talks about after the bail bond has been executed, surety has been taken, the officer who has done this responsible for making the arrest will forward it to the court. So it ensures that a record of the bond is maintained in the judicial system, taking linking the release of the accused with the original warrant. So if the person has not been arrested, the reason only it could be there's an endorsement on the warrant, and if the endorsement of the warrant is there, which means the person has been released on a bail bond, so there should be an evidence. That is why it has to come back to the court which has issued it. So it becomes gives a judicial flexibility, encouragement of the compliance as well, and streamlines the legal process while even issuing a warrant. Now, subsection 74. It's the title is warrants to whom directed. So, number 1, a warrant of arrest shall ordinarily be directed to one or more police officers. But the court issuing such a warrant may, if its immediate execution is necessary and no police officer is immediately available, they can direct it to any other person or persons, and such person or person shall execute the same. So they can execute if the police officer is not there. Then subsection 2 says when a warrant is directed to more officers or persons than one, it may be executed by all or by anyone or more of them. So very simple one where if ordinarily it has to go to a police officer. If it doesn't goes, it goes to the other people. Then the other people are empowered and they have to immediately they have to execute that. And if it is given to one or more persons or police officers, so it may be executed by all of them or by any one of them or more than that. So it could be any number of the people from one to the max number of the people who it has been given to. So if you have 5 people, then the arrest could be made by all the 5 together, or could be made by 1, 2, 3, 4, or 5. So what this is a general directive for arrest warrant. So if a warrant has to be given, arrest has to be made. And what if the condition in where it has gone to a police or a non-police, or it has gone to one or more than one people? So this outlines a standard protocol for issuance of arrest warrant, establishing they are typically directed to the police officer, but ensures that law enforcement it can be given to non-police officers also. So it gives a flexibility in execution, where again it talks about an immediate execution. What is more important is immediate execution, and the number of people are making that arrest or police non-police is completely depending upon it's an immediate execution or not. So what is important is the provision allows the judicial process to maintain momentum in urgent situations, and then even if there is no police officer available there, it could be provision. Subsection 2 talks about the execution by a multiple officers or person, which is it gives a flexibility depending upon the need that the enforcement can be done by one or several or all of them. So this flexibility is execution increases the efficiency of the law enforcement, and they are not depending upon presence of somebody else, and they can still execute if the person whose name is also there to be executing the warrant. So it gives a efficiency, it gives a collaboration possibility. It doesn't stops anybody to just collaborate. It probably gives a permission to an individual also to go ahead and stand and execute a warrant, and it maintains at the end of the day an order. Section 75, which is warrant may be directed to any person. So the chief judicial magistrate or a magistrate of the first class, which is JMFC, may direct a warrant to any person within his local jurisdiction, any person, for the arrest of any escaped convict, proclaimed offender, or of any person who is accused of a non-bailable offense and evading arrest. So they can give it to anybody, not only the police officer. So such person, on receipt of such an order, shall acknowledge in writing the receipt of the warrant. So they have to go and take this warrant order, and they have to acknowledge in the writing that they have received the warrant, and shall execute if the person for whose arrest it was issued is in or enters on any land or other property under his charge. So once it is issued as per section 75 to any other person, and it's within the local jurisdiction of those that court to arrest of an escaped convict, proclaimed offender, etc., etc. This person has a right to arrest the person in all those varieties of people, but the person, if the person enters the property under his charge. So this is something only applicable when the such a person, criminal or proclaimed offender, etc., is entering their premises, and then the person has a right to execute it within his premises. So it is not that he can go to various places to find and search and those people and arrest them. No, it is not allowed under this particular section. Under 75, that is something if only the person enters the estates of that particular person. So it says authority to directly arrest warrant is given in subsection 1, and which says escaped convicts, proclaimed offender, and evasion of arrest. These kind of people are subject of this section. And requirement for execution of warrant is that the individual to whom the warrant is directed must acknowledge first. And only they can arrest when the person, these escaped convicts or proclaimed offenders, evasion of arrest, making such people are entering the property of this person. So only under the land or the property which is assigned to that individual executing the warrant, only if that is under that property, if the person is entering, then only the warrant can be issued. Otherwise not. The procedure following an arrest is upon the arrest of the person named in the warrant, which is subsection 3, the individual must be handed over along with the warrant to the nearest police officer. The step is crucial to ensure proper custody of our legal continuity. So there is legal continuity. For that, the police will pick up the person and bring them to the magistrate. The police officer in that responsible taking arrested individual before a magistrate and appropriate jurisdiction to handle the case ensuring that the legal process is followed. Now let's go to section 79 to section 83, which is also part of the same chapter 6 and part B, warrant of arrest. So section 79 says where warrant may be executed. So a warrant of an arrest may be executed at any place in India. Again, it's a national scope given, and the warrant of arrest may be considered to be executed at any place in India. Throughout the India, it's a broad applicability. It is crucial for the effective law enforcement, and it will allow the officer to their purpose of apprehending the suspect and regardless of the geographical boundaries. And the implication is this brings an accountability where the warrant has to be enforced across the country. The officer cannot go back and not be accountable for uh, a particular execution of the warrant because it's not in his or her jurisdiction. Again, it is also empowering them also, if you see from that perspective, to go across India. And it's an interjurisdictional cooperation which is motivated by this kind of section. So this is a prompt enforcement which happens, maintaining an order, and this happens very promptly, irrespective of being in jurisdiction and being by far into a very different jurisdiction. Chapter Section 80 is warrant forwarded for execution outside jurisdiction. So although you are allowed to uh, execute the warrant outside, but then it might sometime happen then when a warrant is to be executed outside the local jurisdiction of the court issuing it, such court may, instead of directing the warrant to a police officer, who can again go across India within his jurisdiction, forward it by post or otherwise to a executive magistrate or district superintendent of police or commissioner of police within the local limit of whose jurisdiction it is to be executed. So they can also send it via postal services and other means to those executive magistrates or the district police officers, senior police officers who can receive it and execute it within their local limits of their jurisdiction. And the executive magistrate or district superintendent or commissioner shall endorse his name. So the moment they receive it, they will endorse a name and if practicable, cause it to be executed in the manner hereinafter, before provided. So then they have to get it executed. So these might be cases where you have somebody who is which is a gang, which is a very strong gang present in that area. You cannot send a police officer from a completely alien land to go and make such arrest of such criminals because it might need the specialization and knowledge, etc., from the local police. In that case, instead of sending a host of police officers from this area, the court might uh, have a officer who is working in that area to be able to arrest that person. Subsection 2 says the court issuing a warrant under subsection 1 shall forward along with the warrant. What they have to forward, of course, the things which make sense about that particular warrant. So, the substance of the information against the person, because then they will be aware whom they are going to arresting and for why. The name of the person, details of the person arrested together with such document, if any, as may be sufficient to enable the court acting under section 83 to decide whether bail should or should not be granted to the person. So the document also is important for the person's ability to secure a bail for him or herself in case of such an order is passed to that alien district police officers or the executive magistrate. So this is an authority to forward warrant. So courts have an authority to forward warrant. That is what is given by this section. So instead of they have an option to give it to police officer, but probably because of some practical challenges, etc., that they can be given it to the local police officer and it could be sent forwarded to those officers. So execution for local authorities subsection 1 is where the warrant when it is forwarded made directed to the executive magistrate or the police officers mentioned. And the endorsement is required from those people that this is what I endorse it, it is received at this end, and there is a date also which is affixed with the signature. And this is a practical execution so that the authority is expected to execute the warrant as per the established procedure detailed in the legal framework. They can do it but the accountability is of the head of that particular area. Supporting documentations are very, very much important to send so that the document should be sufficient to help the court acting under Section 83 determine whether bail to be granted or not. In case the person, you have sent a arrest warrant to the different district, the person might immediately go and file a bail application. In those cases, the police also receives along with that the details about those things to ensure that the all relevant materials are available to assist in legal proceedings. Now, the Supreme Court in last week has mandated that for any bail application, it is very, very important that all the criminal antecedents of that person also has to be part of the bail application. So, if you are going for a bail application for a person X, then if X has any criminal records, any past conviction or FIR or any such thing, which is against the person in various police stations, those also to be reflecting in the bail application. So what is the implication on this section is, as per the judgment happened in the last week, the document which is supporting, which has to go, will also carry the antecedents of that person as well, where that is something which has to be considered for the bail application going forward as per the Supreme Court instructions. So the practical implication is in interjudicial cooperation in case of need. It gives an efficiency in the law enforcement. It gives a clarity and informed decision making can happen. Let's talk about section 81, which is warrant directed to police officers for executing outside jurisdiction. Now, that was a situation where warrant was not given to the police officer. It was given to the court therein, or the executive magistrate therein, or the police officers to execute in that local jurisdiction. This is where a warrant directed to police officer for execution outside. So when this warrant which has been gone directed to a police officer is to be executed beyond the local jurisdiction of the court issuing the same, he shall ordinarily take it for endorsement either to a executive magistrate or to a police officer not below the rank of an officer in charge of a police station within the local limits of whose jurisdiction the warrant is to be executed. Such magistrate or police officer shall endorse his name. So this is first condition. First two condition where we talk about the standard protocol where the person, when an officer from this jurisdiction goes to another jurisdiction where he has to cause an arrest, the person will go and get an endorsement from the person who is not lesser than of a rank of a officer in charge of a police station where the warrant has to be executed, and the magistrate or the police officer shall endorse his name thereupon, and such endorsement shall be sufficient authority to the police officer to whom the warrant is directed to execute the same, and the local police shall, if so required, assist such officer in executing such warrant. But then there is a second option always given is whenever there is a reason to believe that the delay occasioned by obtaining the endorsement of the magistrate or a police officer within those whose local jurisdiction the warrant is to be executed will prevent such execution. The police officer to whom it is directed may execute the same without such endorsement also in place beyond the local jurisdiction of the court which issued it. So, although the section is silent about all other things, it only mentions about the delay which might happen, and that's the reason you can execute it yourself. But we all know what it means is there might be a nexus between the local police. There might be a leakage of information which might happen within the local police hierarchies. And if there is such a risk, then it is better to execute it directly until and unless you do not have the proper manpower and you needed manpower from the police station in the local jurisdiction where you need a support from them. So basically this section talks about the authority to execute warrants beyond jurisdiction by a police officer who travels from one jurisdiction to the other jurisdiction to arrest somebody, and the endorsement is a requirement in normal conditions where he has to get an endorsement from any magistrate which is an executive magistrate or from a police officer which is not at the rank below the rank of a police station is in charge of a police station. The role of the endorsing authority is to endorse their name on the warrant, which gives an authority to the person, proper authority to the person to execute that. And they again then have to give the obligation also is generated where they have to also give a support by the local police if required by them. But circumstances for immediate execution, they can execute it themselves, and they need not go for an endorsement. They need not go for any kind of such activities. So this is a crucial for law enforcement to act promptly because these safeguards are given. So for the purpose what they are there, it has to happen that way. So it gives an operational flexibility, streamline the arrest procedure, enhance public safety in case of they need more support from the local police station. But it does gives a mechanism to ensure a robust, continual police investigation, etc., is happening under the empowered by such sections. Now, section 82, which is a procedure on arrest of person against whom warrant was issued. Now, you've arrested the person, and what is the procedure of arrest of the person? When you're arresting that person, against whom the warrant is issued. So there is a procedure which has to be followed uniformly to arrest the person against whom the warrant is issued. So when a warrant of arrest is executed outside the district in which it was issued, the person arrested shall, unless the court which issued the warrant is within 30 kilometers or the of the place of arrest, or is nearer than the executive magistrate or district superintendent of the police or commissioner of police within the local jurisdiction of whose jurisdiction the arrest was made, or unless security is taken under section 73, be taken before such magistrate or district superintendent of the commission or the commissioner, and on the arrest of any person referred to in the subsection 1, the police officer shall forthwith give the information regarding such arrest and the place where the arrest person is being held to the designated police officer in the district and to such officer of another district where the arrest person normally resides. So it gives an authority to and process of arrest. So what is the immediate procedure followed by? It's given in subsection 1. It talks about the warrant is executed outside its issuing district. The person arrested must be taken before a magistrate or a relevant authority unless specific conditions are applying. The proximity to the issuing court is one condition where if the distance to the issuing court, which has issued that warrant, is within 30 kilometers from the arrested location, then the arrested person can be taken directly to that court. After 30 kilometers, not. So closer authorities. Then the second option is the second formula is for the closer authorities. First, we talked about the 30 within 30 kilometer. If you are there, no. Then closer authorities. If there is a closer executive magistrate or a district superintendent of police or commissioner of police, then the issuing court, then the arrested individual should be taken to the nearest of these authorities. So, if court in simple sentences, if the court is within 30 kilometers, the issuing court, then they will come to the same court. Otherwise, they will go to these police officers. Out of them, whatever the state protocol says and what is the local protocol says. And again, this is a section which is also being considerate of the section 73, where we have spoken about where a person can be released on appropriate bail bonds and sureties if that is endorsed on that particular warrant. If that is the condition, instead of arresting the person, the bail bond and the sureties has to be collected. So this does not diminify it does not disrespects the section 73. It is inclusive of section 73. Now, the subsection 2 talks about the information reporting requirement. So when all these things happen and happening in a remote place or even in the local place, something happened, what is foremost importance is the reporting requirement. And following the arrest, the police officer is mandated to immediately inform the designated police officer in the district where the arrest occurred. So this information is very important, and the identity of the person arrested has to be disclosed, and the location where the arrested person is being held, where they've kept the person. Both the things have to be mentioned there, and the officer must also notify the police officer in the district where the arrested person normally resides. So there also the police officer also has to be reported. So if the person is arrested from that district which is not the district of his hometown, then that district where it is home also has the police officer of that district also have to be notified. So basically, it's normally go to the commissioner office to commissioner office that way. So this ensures that there is a transparency in communication between law enforcement agencies regarding the individual's legal status and whereabouts. And as we studied today in the starting in one of the sections also, it is something which is amounting to the human right requirements as well. The person is arrested when it is arrested from a different jurisdiction. The local jurisdiction is made aware where the person is arrested. Also, his home jurisdiction is also informed that he is no more coming back to you because we have hold him in some other jurisdiction and now taking him to some other jurisdiction. So it gives a complete cooperation, operational efficiency, but also a clarity on the persons being arrested and holded. So it should not become otherwise it will be called as a illegal detention. If such conditions are not made, it could be easily considered as an illegal detention. Now, section 83, which is procedure by magistrate before whom such person arrested is brought. Now, the person is arrested, and we say in all cases he has to be produced in front of the magistrate. So, the section says the executive magistrate or the district superintendent of the police or the commissioner of police shall, if the person arrested appears to be the person intended by the court. So, verification is something that is first responsibility. If you're picking up somebody in my jurisdiction coming from other jurisdiction, you are picking somebody who is correct. So, and which issued the warrant, direct his removal in the custody to such court. So, if the person arrested appears to be the person intended by the court which issued the warrant, it has to be respected and direct his removal in custody to such court. Provided that if the offense is bailable and such person is ready and willing to give bail bond to the satisfaction of such magistrate, district superintendent, or the commissioner, or a direction has been endorsed under 73 already on the warrant, such person is ready and willing to give the security required by such direction which is endorsed on the warrant, the magistrate, the DSP, or the commissioner shall take such bail bond or security as the case may be and forward the bond to the court which issued the warrant. So why this is required? Because the liberty of the person is foremost important, even if that person is considered an accused. And if section 73 endorsement is already there's no point of arresting that person and forwarding to that court because that person is anyways following the conditions given in the same warrant. But even if it is not endorsed in the warrant, if the conditions are bailable, then they can also take a conscious decision of offering a option of bail bond, sureties, etc., which is then forwarded to the court which has issued the warrant. Why this is done? So that why the court is requiring that person. The court is requiring the person to see his face, no. To meet him and say hello, no. The court is requiring that person to be part of the judicial process, the trial which is happening, and to ensure that the person comes there. So if it happens through 73, they have already have figured out that the person, if given bail bond, will surely come. The same thing, even if it's not part of the endorsement of the bail bond, out of jurisdiction, the other jurisdiction may also again from their side initiate those options to ensure his presence in the judicial process, the trial, and they can also from their side initiate a such kind of bail bond, etc. But provided further that if the offense is a non-bailable offense, it should be lawful for the CJM or the session judge of the district in which the arrest is made or consideration of the information and document referred in subsection 2 of 80 to release such person on bail. So the person is released on a bail bond by these executive magistrate and these police officers only and only in a non-bailable in a bailable condition, while anything which is non-bailable or a serious offense, the subject of determining if the bail has to be given or not is done by the local jurisdiction, judicial magistrate, or the session judge. So nothing in this section shall be deemed to be prevent a police officer from taking security under section 73. So anything, whatever procedure given, the person, any police officer can utilize the endorsed section 73 endorsement and let the person be free by recovering those bail bonds and sureties arrangement from them. So this is an authority of for executing the officers for the arrest. In case of bailable offences, the provision is given. The police officers can release on 73 or on a new bail bond or sureties. While non-bailable offences, it is only the CJM and the session court which can do it. And officer's authority to take security is also given that it is irrespective of anything. So 73 is constant. If the officer wants to go with section 73 provisions, And if it is possible, it is already endorsed, then there is no questions asked on that ability of that police officer that he or she cannot take a bail bond and release the person. So we have completed up to section 83 today in chapter 4.